Many Texans believe that if they have a will, their family won't have to deal with probate. That's one of the most common misunderstandings I hear in estate planning. A will is important. In fact, for many families, it is one of the most important legal documents they will ever sign. But a will does not avoid probate. In this video, I'll explain what a will actually does, why probate may still be required, and what additional planning may help your family avoid probate in Texas. A will is basically a set of legal instructions. It says who should receive your property when you die. It says who you want to serve as executor. It can name guardians for minor children. It can also include language that makes the probate process easier for your family. But the will itself does not automatically transfer property. That's the part many people miss. A will says what should happen, but someone still needs legal authority to carry it out. Probate is the court process where the will is recognized and the executor is given legal authority to act for the estate. That authority matters. The executor may need to deal with banks, transfer property, pay debts, sell estate assets, or distribute property to the people named in the will. A will names the person you want to serve as your executor. Probate gives that person the legal authority to serve. Here is the part that surprises many families. A person may have a valid will signed and stored safely. The will may clearly say who inherits everything. It may name a trusted child or family member as executor, but after death, banks, title companies, and county deed records may still require proof that the court has accepted the will and appointed the executor. That is why the will often has to be admitted to probate. For example, suppose your house is titled only in your name when you die. Your will may say that the house goes to your children, but the deed records still show you as the owner. Because you can no longer sign a deed, someone else must have legal authority to transfer the property. That usually means the will has to go through probate unless other planning was done during your lifetime. This does not mean a will is useless. A good Texas will can make probate much easier. It can name an independent executor. It can waive bond. It can reduce court supervision. It can make clear who is in charge and who receives the property. So the problem is not having a will. The problem is assuming the will does more than it actually does. If your goal is to avoid probate, your plan usually needs tools to transfer property outside probate. That may include beneficiary designations on life insurance, retirement accounts, or certain bank and investment accounts. In Texas real estate, a transfer on death deed may be used if properly prepared and recorded during life. In some cases, it may include a revocable living trust. A living trust can help avoid probate in the right situation, but simply signing a trust document is not enough. The right assets must be transferred to or coordinated with the trust. If everything remains titled in your name alone, your family may still face a probate problem. That is why estate planning is not only about documents, it is also about how your property is titled. The real question is not just, do I have a will? The better question is, will my plan actually work the way my family thinks it will? If your family believes the will avoids probate, but your house, bank accounts, or other assets are still titled in your name alone, they may be surprised later. They may still need court involvement. They may still need an executor appointed. They may still need legal authority before property can be transferred. The bottom line is this. A will is important, but it does not automatically avoid probate in Texas. A will gives instructions. Probate gives legal authority. If your goal is simply to say who receives your property and who should serve as executor, a will may be enough. But if your goal is to avoid probate, keep things private, or make the process easier for your family, you may need additional planning. I've written a full article on this topic called A Will Does Not Avoid Probate in Texas. You can find the link in the description below. And if you are not sure whether your current estate plan avoids probate or simply prepares your family for probate, it may be time to have your documents reviewed.